May I please, Lordship?
Yes.
Lordship, I beg to mention one leftover matter from yesterday. That is, Lordship, criminal appeal number 20 of 24 with IN number 67 of 2024. Lordship, due to paucity of time, yesterday the matter could not be taken up.
Yes.
Therefore,
So it will go after vacation.
Lordship,
It will go after the vacation, madam. What is the urgency in that?
Lordship, the convict is under custody.
No, I mean, of course, it's an appeal. So it will come out after the vacation. Mention it after the vacation.
Obliged.
Well, item number 10, my lord, the special PP, my lord, he morning informal, he's out of station, my lord.
Item number 10.
10, my lord. So he requests me to inform the court. So this is for hearing today.
So when do you want it?
My lord, is in month of my lord, March, my lord, I have some, otherwise, my lord,
Month of?
March, my lord, 2nd of March, my lord.
It will be too far, isn't
My
it?
lord, otherwise, my lord, again, I have to, my calendar also busy in outside the Guwahati, my lord.
We have done what he consented to that.
Yes, my lord, yes.
The month of March.
Yes, my lord. Because the case before session is 9th of March, my lord. Yesterday order is-
9th of March.
Yes, my lord.
So we'll fix it up sometime in the later half of the February.
February, then 27 February, my lord.
Yes, 27 February we can
Yes,
fix it.
27 February.
Heard Mr. S.K. Mehdi, the learned CGC.
My lord, I'm not in here in CGC, my lord, but it was reflected CGC, my lord.
Or is reflected as CGC.
Yes,
So you are the petitioner.
yes, my lord.
The learned counsel appearing for the petitioner submits that submits with consent from the counsel appearing for the other side that the matter may be listed in the listed on 27th of
February.
27th of February. February prayer is allowed. Let the matter be fixed on 27th of February for hearing.
Yes, my lord. There is the interim order.
Interim order superstitious shall continue till the next date of listing.
Highly appreciated.
May I please hear?
Yes.
Lordship, I beg to mention one unlisted anticipatory bail application, Your Lordship.
Unlisted anticipatory.
Much a pleasure.
Item number 1.
May I please, Your Lordship?
Yes.
But in this matter, we are challenging the impugned order passed by the district and session judge. In fact, the judgment and order of the CJM, Chief Judicial Magistrate, judgment and order passed on 8/12/2023, which was challenged before the district and session judge in the criminal appeal. But then the criminal appeal was dismissed on 22/10/2025. So now we are challenging the judgment and order
On what
passed by the.
ground?
My lord?
On what ground is it?
My lord, we have met grounds, my lord, Your Lordship.
It is statutory, right?
Yes.
Ginny, it's statutory.
Yes.
But the important ground is that, my lord, CJM has acquitted, there was 4 sections, 468, 471, and 420. CGM has convicted under only 420 IPC. But then in appeal, district and session judge has reversed, confirmed the 420 and
Additionally made.
set aside that 2 sections and convicted under 3 sections, which was the part of the investigation, which was a part of the trial. And I just will take to impugned judgments is page 176 is the starting of the impugned judgments. And relevant page is 31 and 32. Page 176 is the starting.
Will issue notice, Ms. Jenny?
Yes, Your Lordship. Your Lordship,
Yes.
But there is a IA also.
there is an IA in which the complainant has not been made a party. Also, the provision under which they have come is of appeal, Your Lordship. If they could amend the same in IA, Your Lordship. Lordship, 430 is for suspension of sentence pending appeal, Your Lordship.
Hmm.
Whereas they ought to have come under 438, which is that during the exercise of the power of revision, the court can suspend the conviction order.
Yes, Mr.
My lord, yes, in fact, we have missed to even made the complaint party. I mean, in fact, in the criminal revision petition, we have made party, but we have missed.
But you'll have to make it here.
Yes, yes.
So
So I may be allowed to amend that IEA. And
then an effective order cannot be passed today. You'll
Oh,
have to
my-
amend it. You'll have to amend it.
yes, only especially in the IEA, my lord.
Especially the IA.
IEA, my lord.
IA.
Otherwise, I would have prayed for the bail, but then that
Correct.
is.
I mean, without that, the complaint.
Yeah, my lord.
party,
Then I will file the amended petition.
You file an IA for
Yes.
amendment, then IA will be allowed.
Yes, my lord.
Then you can file the, amended cost title.
Yes, yes. And then the matter can be heard in next date fix. My lord, we will file.
Next date that can be heard, but as far as your suspension of sentence,
Yes, yes, yes.
that will be heard on the next date.
Next date, yes.
Next date, you can file it in the meantime.
Yes, yes. That's
But IA has to be considered. IA has to be considered and allowed, then you'll have
Yes.
to file a amended cost title also.
yes, my lord.
So at
My
the
lord,
same
my
time, you
lord,
can't do that.
My lord, I will pray that your lordship, if you allow for the amendment right now, I will file the amended.
No, without the application, how will I allow the amendment? You'll have to file an IA. Heard, Mr.
Then-
So and so the learned counsel appearing for the in the IA, appearing for the applicant. He submits that by some inadvertent mistake, the complainant has not been made has not been made a party in the instant IA. Therefore, he prays for a date so that he can file an interlocutory application for praying for amendment of the cost title. If the prayer is allowed, let the matter be fixed on.
5th of January, my lord.
50 is a holiday, so let the matter be fixed on 8th of January. 8th of January.
Okay. Well, before that, if
Before that, there is no date.
Okay, then.
You'll have to file an IA. The order has to be passed on IA only.
oblige.
In
8.
in the connecting of appeal also, let the matter be listed on 8th.
Detail.
So if file an IA, the IA will be in the IA, there will be an order passed.
Yes.
Allowing you to amend it, then you'll have to file an amended cost title.
Cost-
So the process has gone little bit
Oblige. Yes.
long and be held.
Oblige.
Item number 2.
Ms. Jeannie, Learned APP, APS for the state.
May it please your lordship. Lordship, this is in bail application.
And DPS.
Yes, lordship.
So we'll call for the.
Yes, there is. Lordship, there is something, actually, this is a bailable offense.
Hmm.
But however, it has been
So
recorded.
we'll have to see the case there.
Lordship, I have annexed the sampling order, Lordship.
Sampling order will not do. You have to see the case diary. Heard Mr. So-and-so, learned counsel appearing for the accused applicant, also heard Mr. T. the learned APP for the state. This is an application under section 483 of BNSS 2023, praying for granting bail. Your bail was already rejected once.
Yes, Lordship, on
bail-
12th November, Lordship.
Huh?
12th November.
Bail to the accused applicant in connection with ITPS case number 156/2025 under section 21 in bracket small b stroke 27 bracket capital A stroke 29 NDPS Act. NDPS Act, full stop. Call for the CD, let the matter be fixed on. When do you want it?
Lordship, I'll humbly submit, Lordship, when the sections are available, there are catenas of citation which says it's an absolute right of the accused, Lordship.
But how do we know that, what is there? in the
My lord,
case?
I have annexed
section clearly reflected is 27A, my lord.
Hmm.
So if 27A is there, it's a illicit, my lord, trafficking. It's an punishment is section up to 10 years. It's non-bailable. From where the submission is
I mean,
coming?
how the court will decide now? How the court will know? I mean, what is the allegation? Please show me that. What is the allegation? And how you are saying that 27A is not applicable?
I said
How are you saying that 27A is not applicable in the case?
Lordship, that is not. I mean, like 20. It was
So
supposed to be
27A is there. So 27A is what?
29 is
27A is
okay.
trafficking,
Yes.
is for financing,
Yes, Lordship.
selling. So those allegations are there.
Yes, Lordship.
So, I mean, how do the court will come to a conclusion without looking into the
It's a case.
CD
Yes.
that 27A is not applicable? Because you must have been arrested on the basis of some implication by co-accused or what?
No, my lord. Direct
Directly.
involvement. Direct involvement.
Lordship,
Then
there is a
27
trending which is going on in every NDPS case. They are now imposing 27A.
Because
and 29.
in all because you are doing drugs trafficking, that has to be curtailed. That's why they have put in. So let the matter be fixed on 8th.
No, Lordship,
Or-
right after the vacation.
Maybe on 8, my lord.
After the vacation 8, because 5th and 6th are holidays. Huh?
6th is holiday. 5th is not holiday. But my lord, the record CD has to become. So let it be on 8th itself, man.
5th is Sunday. Oh, sorry. Yes, 5th is
5th opens, 6th is closed, my lord. Maybe on 7th or 8th.
7th or 8th.
7th or 8th.
8th,
7th,
7th,
yes, my lord. Oblige, my lord.
Obliged. Lordship.
Item
Now,
number 3.
see, Mr. Discord would have been happy to dispose of the matter, hearing a matter, but that can be done. That cannot be done with this. Otherwise, it would have been, and Discord would have been happy to dispose of one matter.
Lordship, I have the case actually, but also
Yeah,
there
see,
is no CD.
this court would have been happy. That's what I'm saying. This court would have been happier to dispose of a matter.
Yes, sir.
But thing is that it can't be disposed of at this stage. So CD has to come.
Obliged.
Item number 3.
B, please, Lordship.
Yes.
Application under 482
Hmm.
for anticipatory bail.
Where is
My
where is the FIR?
FIR is my page 14, my lord.
Is 14.
Page 14. May I read, my lord?
Yes.
It is to inform that on 18 December 2025 at around 21 hours, an incident of physical altercation and assault damage to the government property, conspiracy against the serving personnel, hurting the religious sentiment, and also instigating the communal discord took place near headquarter 28 RCC, Lemaking area under the jurisdiction of Air Police Station. During the said Gentamra, actually Mara, it's Gentamra and Yasamra. I am is Yasamra, my lord. And some unidentified civilians who appeared to be under influence of alcohol for creating disturbance and hurting abusive language and damaging the government property by throwing stones and using dao at main gate, threatening to burn alive to the serving personnel and to put fire on main gate. Put fire at headquarter 128 RCC. The manner in which the around 10 to 15 civilian gathered and acted indicated a conspiracy to create nuisance and confrontation by giving a threat to put fire if any vehicle moved outside from the headquarters RCC. The two TA, territorial army soldiers who were on bona fide duty at the main gate intervened only to restrain the civilian and prevent further disturbance in the interest of maintaining discipline, public order, and security of the unit. However, the intoxicated individuals became aggressive and started assaulting the on-duty TA personnel with stone and dog, resulting in grievous heart and eyes injuries to them. Also thrown stones on the unit mandir and unit shelterers, hurting the religious sentiments and causing damage to the government property. The detail of the injured territorial army personnel are as under. This is one Asim Rai, both are Havildar, and Nilay Bhuyan, both are Havildar. The photographs of the main accused Gantamara, Yasamra, along with some unidentified civilians were
Yes,
attached.
Mr. Ate?
Yes.
Yes, my lord, call for the case diary, my lord. Here, my lord, one more thing is there, my lord, they have not mentioned the PDPP section in their petition, but it, their
What?
PDPP section, my lord. In their application anywhere, they ought to have mentioned it, my lord. They only section of PDPP Act. But however, your lordship, we can call it from the FIR. It's a 3 of PDPP, my lord. Nowhere in the petition they have mentioned it, my lord. I'm just highlighting it, my lord. Otherwise, FIR is there.
Yeah, FIR is there.
Yes, my lord. So, my lord, CD may be called for, and my lord, since there was your lordship, they counter FIR is also there, my lord. You'll
Yes,
find in
Page 15.
para 15, my lord.
Yeah, this I have seen.
Yes, my lord. It seems like your lordship, there is some kind of land dispute is also there between them. So, your lordship, to a
Between whom?
certain
Between whom?
grip and, my lord, this residence, my lord. The landowner have not yet agreed with permanent allotment of the land to the grip and the camp, my lord.
Landowner is who? Who is the landowner? Is some relative of this guy?
Accused persons, sir.
Hmm?
The landowner. The LS, father of the LS accused persons and some others are landowners. There's a mutually handed over the land.
Mhm.
The main cause of, the root cause of the dispute is that, my lord, the connecting road goes through the camp, so-called grief camp, and the accused number 1 wanted to visit the accused number 2, that is elder sister. I am elder sister of the accused number 1, but in between, in the evening, when he was proceeding to his elder sister house, then these 2 territorial army obstruct him. Why you are coming like this? Then he said that this is the only way to visit my relatives' village. Why I should not go? Then on this only, they argued, and the 2 territorial army brutally beaten the accused number 1, Gentemra. And having heard that my brother has been beaten brutally by the territorial army, I went to the spot. Then in the meantime, there were so many people gathering. It is a mob lens started. So who has stone pelt, who has pelting the stone? It was nobody knows. It is getting dark. It's many people are gathering. That I am innocent, my lord. I am the elder sister of the accused number 1 who received grievous injury on beating of the.
So, I mean, you are a lady.
I'm lady, my lord. I'm innocent in the
Two bail application, my lord. One is the accused and one is the co-accused, the lady, the sister of the accused, my lord.
Yes.
So,
So
they,
I am.
The sister of the accused can go, I think.
yes, my lord, she was there. She was also there when she come to learn that these things happen.
Yes.
She went there and these things, my lord, happened. So, that can be done, my lord, with the strict direction, my lord.
My lord, I am the mother of 6 months.
There's
innocent
another bail
infant
application.
Yes, my lord. One is
child.
from the brother and one is the sister, my lord.
Similar case, my lord, analogous.
176 bail application is for the sister, my lord.
Sister, my lord.
Her name is also there in the, my lord, FIR otherwise.
Yeah, in the affair I have seen.
Yes, yes.
Yasa. I am Yasa Mra.
I don't think CD is required in this matter.
Yes, my lord. See this, it's a clear case, madam.
Heard, Mr.
Udeka, my lord.
Udeka,
Yes.
Udeka, the learned counsel appearing for the accused applicant, also heard Mr. T.A.T., the learned APP for the state. This is an application under section 482 in bracket 1 of BNSS praying for pre-arrest bail to the accused applicant in connection with Nacho PS case number 05/2025 under section 118 in bracket 2/121/351 in bracket capital B.
No, my lord, it's 3, my lord. It's wrongly written. It's 3, my lord.
Which one?
3. It's not B, my lord. 351.
Haha,
Three.
it should be 3.
Yes, there is no any such provision in BNS.
Sorry, my lord, because it's a typographical mistake.
3/298/3 bracket 5 of BNSS 2023. Read with section
3 of PDPP.
3 of PDPP Act. PDPP Act, full stop. The gist of the allegation, next para, the gist of the allegation as narrated in the FIR dated 18/12/2025 is that at about 21 hours, the accused applicant along with her brother, namely Yacha Mara, and some unidentified civilians gathered before HO 128 RCC in bracket Lime King in bracket complete area, Lime King area, under the influence of alcohol and started disturbing and abusing the policemen on duty. Those are policemen or what? No,
No,
those are
They are grip
My lord.
police, my lord.
grip is what?
That is,
What is the full meaning of grip?
My lord, grip, my lord. General Reserve
General Reserve,
Engineering Force.
GREP.
Yes, my lord.
GREP personnel. GREP personnel stationed there.
Yes.
Stationed there. Though there was it was alleged that though there was an effort from the GREP officials to stop such activities, the accused applicant, along with others, started pelting stones using abusive languages and thereby caused injuries to two TA personnel. TA means what?
They are Havaldar, my lord.
Hmm?
They are Havaldar, rank Havaldar, my lord.
Two of the Havildars,
Asim Roy and
two of
Neelam.
the Havildars present there. Full stop.
Okay. The TI is Territorial Army.
Okay. It was also alleged that the intoxicated individuals, after becoming aggressive, destroyed certain public properties. They means certain public properties, stroke government properties. It was also alleged that they have hurted the religious sentiments of the officials present there. Full stop. In view of the aforesaid, the FIR was lodged by
Name,
Major
Major Captain. Name
stroke Captain stroke AE,
Jibil.
Assistant Engineer.
Assistant Engineer in bracket CIV CIV before the officer in charge of outpost police
Nacho.
Lim King,
Lim King,
Lim King, yes.
Lim King, full stop. Full stop. On receipt of the FIR, the police registered Nacho Police Station case number 05/2025 under the aforementioned sections. Full stop. The learned counsel appearing for the accused applicant submits that the accused applicant is nowhere involved in such alleged incident. Such alleged incident as contended in the FIR. He submits that the accused applicant is in fact the brother of the co-accused, namely Gente.
But Yasa Mara is the sister, my lord.
Elder sister, my lord.
Yasa Mara is sister and Getne Mara is the brother, my lord.
Getne Mara.
Is the brother, my lord.
So Getne Mara is the brother.
Yes, ma'am.
Yacha is the applicant.
Sister, yes.
Getne Mara, brother of Getne Mara, and in fact Getne Mara wanted to visit her residence.
My lord, Yasa Mara, my lord.
Huh?
My lord, Yasa Mara is the sister, my lord. Getne Mara is the brother.
Yacha Mara is this thing, right? I mean the applicant.
Sister, yes. Sister, my lord.
Sister of whom?
My lord, yeah, Getne Mara.
My lord is right. Gantamara wanted to visit the house of his sister Yasama.
No, I mean see, Yacha is also one of the accused.
Yes,
right?
my lord. But
So-
sister.
So this application is for Yacha Mara.
Yes, ma'am.
Herself.
Get-
Correct. So I mean, this Gantemara wanted to visit the house of Yachamara.
Yes, yes.
Correct.
Yes. Yasa Mara is the sister, my lord.
Sister.
Yes.
So what was written there?
This applicant is nowhere involved in such
Hmm.
incident.
Hmm.
Was contended in the FIR. He submits that this applicant is in fact the brother of the accused.
Sister of the co-accused Getnemara.
Yes.
Getnemara, and Getnemara wanted to visit her residence crossing the gate wherein those grip officials were present. Full stop. He submits that while crossing the gate, the police or the grip officials questioned him about his questioned him about his going questioned him about his visit and at that time there was some altercation occurred between the Getne Mara and the officials present. And when the accused applicant got to know about the incident, she also came and joined there.
Yes, my lord.
While the altercation was going on, there was some there was some hue and cry and people and some local people gathered there, and local people gathered there and she is not aware. He submits that she was not aware as to who had pelted stones or tried to damage the public property. Full stop. In view of the aforesaid, he submits that in fact the accused applicant is totally unaware about any damage of public property, and in fact she had visited the place only because her brother was involved in the altercation. Full stop. He further submits that the accused applicant being a lady and she is fully and she is willing to, and she is very much willing to cooperate with the investigation in the matter, she should be allowed to go on pre-arrest bail at this stage, full stop. The learned APP, Mr. T. Atel, on the other hand, submits that case diary in the case is necessary for consideration of the pre-arrest bill at this stage. At this stage, full stop. This court has gone through. The materials brought before this before this court. No, you write one more sentence. I mean, before the submission. In submission, you write in the learned counsel further submits that in fact one FIR dated 19/12/2025 was lodged by one Chuge
Mara.
Chugemara is who?
Father of the.
Chugemara,
ENY.
the father of the accused applicant about the assault, about the physical assault by the GREF personnel on the accused applicant as well as on his son, full stop. After taking into account the materials brought before this court as well as after hearing the submission made by the respective parties, this court is of the considered opinion that this is a case wherein the anticipatory bail should be granted to the accused applicant at this stage. Accordingly, in the event of accordingly, it is directed that in the event of the arrest of the accused applicant by the investigating officer in connection with Nacho PS case number 05/2025, the accused applicant shall be released on furnishing of a bail bond of rupees 20,000 with a surety of like amount to the satisfaction of the investigating officer, to the satisfaction of the arresting officer, subject to the following conditions: that the accused applicant shall appear before the investigating officer within 10 days of passing of this order, number one. Number two, that the accused applicant shall cooperate with the investigation and appear and make herself available as and when called for by the investigating officer, full stop. Next, number three, that the accused applicant shall not try to temper or hamper with the investigation in the instant case. Next para, in view of the aforesaid direction, the instant bail application, instant PRS bail application is disposed of as allowed.
Yes, my lord, one rather that your lordship, the finding is only confined to the bail, my lord. This finding of this honorable court regarding her involvement, my lord, because this case is under investigation, my lord. Your lordship.
This is prima facie. This is
Yes,
the
yes.
bails are only about prima facie only. That
Yes.
My lord.
there is no finding. I mean, there is no material to give any finding. This is only on the basis of, the whatever there in the thing.
Yes, my lord, that is there, my lord. Sometimes this,
I'm not giving any finding. That is his submission. I'm writing.
okay, man.
Yes.
This is submission. It's not my. I have my thing is only that I have considered the submissions and went through the materials and given bail to him.
Okay, man.
Bail to her.
Yes, man.
See, in this matter also, you write heard so and so. Then you write the gist of the matter. Then you write call for the CD. Call for the CD and let the matter be fixed on
9.
8th of January.
Okay.
See, as far as this person is concerned, we'll look into the case diary. So on the next date, it will be decided.
Interim protection maybe now.
Yes, my lord. Yes, man. I'll leave it to your lordship.
Treatment, my lord.
Let him-
Interim protection maybe.
Then you have call for the CD so and so, and in interim, you write in interim, the accused applicant in the event of the accused applicant is arrested by the investigating officer in connection with Nacho PS case number 05/2025. 25, he shall be released on furnishing of bail bond of rupees 20,000, and all others will be same. He'll cooperate in all these things. He'll appear before this. All these things will be same. Only thing is that case that is called for.
You can copy of case diary.
I will correct the order.
Yes.
Little bit of here and there.
Oblige.
Item number 5.
Yes, this matter.
My lordship, I am confining my prayer.
Hmm?
I am confining my prayer very limited with.
So what is to be done? You tell
yes,
me.
Lordship.
I mean, there are, I mean, this is an offense which is a public offense. It's not a private offense.
Yes, lordship.
Correct. A
that-
person is dead and somebody is coming and like paying some money to the wife
Yes, lordship.
and the victim is not there to consent. Victim is not there to, I mean, do anything on that.
Yes.
And this has a lot of ramifications on the society. So in that view of the matter, though we have considered this case earlier, but this court has gone through, I mean, certain materials, and after going through certain materials, this court has, I mean, I think this court has to consider the matter afresh.
Lordship, yes, similar situated case in Ojing Daring case and this Sanjay, which lordship has passed earlier. Lordship,
But at that
lordship, the
time-
section.
At that point of time, neither this from the state side nor from this side, certain cases which have been decided, Supreme Court has said certain things about certain cases. Those were not pointed out before this court.
Yes, in that case, lordship may conduct the proper hearing and till such a returnable that proceeding may be.
No, in the hearing is already there.
Yes.
I mean, done.
Yes.
So what we will do is we will, Miss Jeannie, you have to say something.
Your Lordship, since we have also on many occasions disposed such cases, my only submission before this court is that every case has their own facts and circumstances, Your Lordship.
No. I
Some-
mean, see, facts and circumstances different, but like this is a case wherein, I mean, there is an accident, correct?
Yes, Your Lordship.
And there is this, I mean, there is no denial of the fact that the person was involved.
Yes,
He has taken the vehicle without asking the owner.
yes,
Then he was intoxicated.
yes,
He met with an accident. He dragged the body for 1.5 kilometers.
yes,
Then he ran away.
yes,
Then the trial is going on. Depositions have been made.
yes,
I mean, the allegation, I mean, that the person who owns the vehicle, the department, the director,
yes, yes,
he has implicated him,
Yes.
saying that without telling him, without telling him the vehicle was taken.
yes.
So there are some prima facie
Yes.
material against this person, correct?
Yes, absolutely.
Now, only thing is that they have come to a compromise,
Yes, Your Lordship.
paying a huge amount.
Yes.
So see now, the Chris court is only concerned. I mean, in this kind of criminal offences, is if a rich person who has money and he pays the money and compound the cases. I mean, this is what kind of I mean effect the society. I mean, we as a society. I mean, effect on the society it will have.
Absolutely.
Because otherwise everybody will think that I mean I will commit this kind of a thing and I will pay the money and I'm scot free.
Yes, Your Lordship.
This cannot be done.
Absolutely.
Correct.
Absolutely, that
I mean,
cannot
this
be done.
this is this has a lot of impact on the society.
Yes.
I mean, see, last time this is correct that the facts are a little bit different, but because in those cases that implication was not there.
Yes.
I mean, in the trial, the implication was not there because
Lordship, in
see, I'm telling you, because the person who committed the thing and the witnesses did not turn up.
Yes.
Here, the witnesses have turned up. I mean, the person director has turned up. Director has implicated him, correct? And this lady, that wife has also come to the court and she has made a statement that like her husband was killed
Yes.
by an accident. But cross-examination was not done.
Yeah.
So that implications are there.
yes,
So it is not a case wherein she did not go to the court. She became hostile. She did not say that there was an accident involving these people. It was not like that.
Lordship,
So
in,
it was a different case.
yes, Lordship, in cross, his the wife of deceased, they have accepted that they have received the compensation amount, and she doesn't
No,
want
no,
to pursue the case.
that's what
In
I'm
cross,
saying.
Lordship,
What closed?
cross examination that wife.
There is no denial that the money has been accepted.
Yes, and she has stated that.
No, now thing is that like if somebody, let me see,
Yes.
take an instance.
Yeah.
I mean, now these cases like BMW cases happened. You know, you are aware of this in Delhi. BMW case happened. A person who is a rich person, his son is driving a vehicle. Yeah, he met with an accident. He was intoxicated and he met with an accident. And next day he comes and like he pays 1 crore or 2 crores of rupees to the victim's family. And victim's family also like already the person has died. What is to be done with going ahead, the putting inside the jail? They may think like that. There are a lot of families they'll think like that. And a lot of families are there, they're going through a distress, they need some money. And in those cases, like if the compromise can be done in all the cases, it will be difficult for the society.
Yes, Lordship, it is there, but Lordship, in this case, that the accused person, both the accused person, they are unemployed youth now. Lordship,
No,
Lordship, even
That
being
that is more.
yes, Lordship, even being an unemployed youth, they have at least managed such a huge amount. In not as a compensation exactly, it is a reasonable amount that is that is extended as a financial help assistance to the aggrieved family.
In
Lordship.
this kind of cases,
Since the
in this kind of cases, that compensation is additional.
Yes,
yes,
it can
not
be
exactly not as a compensation, it is a financial assistance.
Whatever you pay, financial
extended to the
whatever
aggrieved
name-
family,
whatever
Lordship.
name you give,
Yes.
financial assistance or whatever, it's additional
Yes,
to
Lordship.
the panel to the panel provision.
Yes, Lordship, I do accept, Lordship, but
so-
Lordship, further proceedings and if the trial is permitted to commence, Lordship, that again, it would be a
like,
abuse
I
of
mean,
process of law, Lordship, since
I mean, Ginny,
you'll
have to have something. Then you tell me I'm reserving the judgment of this.
No, Your Lordship, I absolutely agree with Your Lordship. In fact, the Apex Court has also stated that compensation cannot be a sole ground for quashing of cases in rational negligence. My other point is, Your Lordship has rightly pointed out, because why I was stating about the other cases, like there are cases where the disease itself is always on, some of the diseases are on fault, and it's the accused normally takes the deceased to the hospital in such emergency cases. In this matter, Your Lordship,
Correct. I mean, I see. Yeah, I mean, see. I mean, if it would have been a grievous injury, if it would have been an injury,
Yes.
parties have come to a compromise and like helped him out. All this, there is a different thing. But here, the person is no longer there to
Absolutely.
give any give any consent to all these things.
It was more of a culpable, it's what absolutely not a negligence as such.
And
but
here,
then-
here the facts are very disturbing. I mean,
Yes,
facts
yes.
are very disturbing.
Yes.
He was dragged for 1.5 kilometers. I mean, they didn't stop it. They ran away. I mean, this is disturbing.
yes,
These are-
fact is,
and this is not a case wherein, I mean, the whole case has been topsy-turvy. It's not like that. I mean, here the trial is going on in a proper way. The person will be convicted.
yes, Lordship,
I mean, with this evidence,
Yes,
the
Lordship,
person may be convicted.
Lordship, in
That's-
our tribal society, Lordship, what happens if accident happens, then there happens to be some mediation. Lordship, after mediation, that both the parties agrees, then only all those things
See,
come.
this
Lordship.
statute,
Lordship,
Indian Penal Code.
Yes, Lordship, that is there, Lordship, that I.
applies to everyone.
Lordship. But
applies to
in
everyone.
utmost
So let
humility,
me,
Your Lordship,
I mean,
Since-
we understand that
Yes.
now the compromise has happened, the parties are happy.
yes,
That is one aspect
yes.
we'll have to think about. And see, I mean, in this kind of cases, in fact, the courts are divided also.
Otherwise, Lordship,
Certain courts are in the this thing, I mean, settlement thing. Certain courts are not in the
otherwise, Lordship,
But see, listen. But in case of fatal accidents, I mean, difficult.
otherwise, Lordship, this honorable court can afford being heard to the next party, to the opposite party.
Hmm?
Opportunity may be given to the opposite party.
For
Opportunity may be given to the next other parties involved here in Lordship.
It's a common.
Otherwise, Lordship, it would be a abuse of process of law since the accused person and the parties, they have entered into the settlement and have paid
no,
that extended financial assistance to the
correct,
aggrieved
but
family.
I
Lordship.
mean, they will only say that we have compromised. What else? Anything else will be submitted. And this
Since
is
they are living happily, harmoniously, Lordship.
and this is I mean, you do something, then you pay some money, and then say that we are
Absolutely not, Lordship. Absolutely not.
heard, Mister.
Hurrying, Lordship.
And so and Ginny, the learned APP for the state, hearing concluded, judgment reserved. We will write a judgment.
Deeply.
If you feel that the judgment is not good, you can always go.
No, Lordship, that is not absolutely.
You can always go.
Yes.
Because see, like this court, I mean,
Otherwise, Lordship, both the
See,
cases are
see, see,
similarly
see,
situated cases,
I
Lordship.
mean, I'm very fair and honest about all
Yes,
these things.
yes.
I have thought about this.
Yes.
When this judgment, I mean, last time when I came,
Yes.
this judgment was shown to me by a coordinate bench.
Mhm.
I've gone through it in the court. In fact, like I was little bit confused whether to go ahead or not, but I could not, because since the coordinate bench is given And I mean, the parties have come to a compromise, the person is compensated, then taking all these things, I have allowed it. But when I went back, then in fact, it is open court, I mean, I will release it live casted, I'm saying it. Then I went back, I was thought about this matter. Because what will be I mean, effect on the society and all these things. I thought about this, then I tried to look into the materials. Then I found out that there are certain things the court should consider. I mean, court should have considered. So we will, still I'm not saying that, I mean, it cannot be done. Probably it can be done also, but we'll look into it. We'll look into it and we'll decide on this.
Otherwise, Lordship.
Because see, all the materials are there. There is nothing to be,
Calling for the-
nothing I can get it from the CD, right?
Yes, yes.
I mean, all the things he has
Yes,
already
I
already
agree,
given,
yes, Lordship.
statements and all.
Yes.
That is very helpful, in fact.
Lordship.
And yeah, I mean, whatever argument you have, I have heard you. I know what kind of arguments you'll make. And the other part, I mean, there is no, I mean, you have made only the state party.
Yes, Lordship.
Others are jointly you have filed.
Yes, jointly
So
filed.
whom to be heard again?
If, just to satisfy this honorable court that.
No, let
the
us, I
party
mean,
has agreed.
we'll keep it, this thing, reserved. And let's see what can, what base this court can give.
Yes, yes, I leave it with the.
Deeply.
Deeply honored.
Item number 6.
Your Honor, this is joint petition filed by the applicant, accused person and victim and a complainant.
What?
This is joint petition filed by the accused person and victim and informant. Accused person is the applicant number 1 and
What was the allegations?
allegation. I annexed the FIR copy in page number 17. May I read?
Where page?
Page number 17. Complainant against hit and run car bearing number so and so. Respected sir, I am
The person died or what?
not died. He's alive. Only injury was happened.
Okay.
I am Mrs. Pul Khatun, wife of Sri Tajun Uddin, currently residing at Ganga Market near Hotel Blue Pine, Itanagar. Writing this letter in order to report an incident which took place on 13/11/2024. Respected sir, this incident happened near Trekker Stand, Ganga Market, Itanagar in midnight at 12 p.m. A person driving Centro car bearing registration number so and so hit my elder sister, Mrs. Anura Begum, wife of so and so, from her backside and ran away without any response to us. And we brought her the nearest hospital, that is RK Mission Itanagar, with unconscious condition. But the doctor of the RK Mission told us that she got serious internal and external injury. We don't have a equipment and rather refer her to Trims Hospital, Naharlagan. Yes, so we brought her to Trims. Now she is still unstable and unconscious condition. I request you to kindly investigate the matter and find out the best solution to give justice on my sister, who is now fighting for her life in the hospital. And therefore, once again, I highly request you and your God office to kindly trace out that driver and give capital punishment for that. They never repeated such careless act in the near future. And I also want to appeal your good office to kindly book my complaint against that car driver under any appropriate section of law. Your Honor, in this case, the victim, I made an applicant as applicant number 3, and Pul Khatun, who is the informant in this case. On the same day when the FIR was lodged, the party have compromised each other. And after that, they have submitted one withdrawal application. I annex in page number 30. Type copy is page number 30A. May I read? A prayer to withdraw the FIR lodged against Kasar Padun. With due respect, I would like to inform Your Honor that both the parties involved in this incident have agreed to settle the matter with mutual understanding. Mr. Kasar Padun will take full responsibility of his action and he will bear all the medical expenses incurred during the treatment of the victim until she has fully recovered. Therefore, I request you to please withdraw the FIR lodged against Mr. Kasar Padun, as both the parties have agreed mutually settle and dispute after through deliberation. My lord, as per the medical report, the injury was grievous in nature. I have annexed in page number 29. But as per the statement of the victim, which is yes, sir, page number 25.
What is that?
As per the statement of the victim,
Hmm.
in the last para, my whole medical expenses has completely covered by the alleged accused person. Is written in the page number 25, the testimony of the victim. After that, my lord, they have settled the matter outside of the court. I have annexed the deed of agreement on
Lordship, here,
case number
Lordship,
D.
victim, Lordship, is already recovered, Lordship, and moreover, her statement is already clearly stated that alleged accused is fully, completely covered the medical expenses.
So this, I mean, this will come,
Yes,
this will
maybe.
dispose of.
Yes, ma'am.
Tell them write their names. I'll order, I'll pass in the chamber.
Obliged, my lord.
Obliged, Lordship.
Meta sir,
Aseloch.
huh?
Aseloch.
Kitas, so.
7, 8, 9 item Aseloch are unlisted assets.
Seven, eight, nine.
Or unlisted assets.
Seven, somebody is there? We'll finish it up from there. Yes, seven.
Item number 7.
Yes.
So it is a criminal petition for quashing and setting aside of order dated 26/8/2025, passed by the Chief Judicial Magistrate Pasigat, whereby the CJM Pasigat has taken cognizance of perjury in connection with the Likavali PS case number 30/2022 against the petitioner. The fact of the case is that petitioner herein is the prosecution witness number 1. Prosecution witness number 1. Petitioner number is the prosecution witness number 1. And she was called on 26/8/2025 when the impugned order was passed. In her examination in chief, she differs a statement which is little contradictory and inaccurate as compared to the.
Yeah, coming is the cognizance.
No,
Come against what?
he has to follow the section 215.
This was already order passed.
Order pass, yes. Cannot take suo motu cognizance. He has to follow the provision of 215 and 379B and SS. That is why this petitioner is here.
Okay, it will take some time. Then we'll take it up after this.
The
I was
procedure,
thinking that
Lordship,
if
they have
if I could
arranged
have finished it before this, then I could have
Yes, sir.
done it, but like I think the criminal petitions take some time.
Yes. They have only the procedure, Lordship, part, Lordship, the CGM, the perjury, Lordship. In a matter of perjury, the CGM can take cognizance or not, Lordship, directly, Lordship. Actually, 379 is there, Lordship, which is, Lordship, there's procedure to be followed, Lordship, before taking that cognizance, Lordship. That is there, Lordship.
Mm.
We can output, Lordship, we can do that, we can send it back and with proper procedure may be followed, Lordship, that can be, order may be passed.
No, that can be
Yes,
seen.
Lordship.
That can be seen. I mean, this is a complaint, CR case.
No, criminal case.
Criminal case,
No,
Lordship.
criminal case, a complaint case.
Criminal
was.
case, yes, complaint case.
Complaint case.
Yes,
An accused was called before cognizance.
accused person.
Hmm?
Well,
He
next date
was
was
called on the next date.
for examination, Lordship.
On her examination in chief, the cognizance was taken on that day itself. After hearing her deposition statement, I mean, before the magistrate.
Okay, we'll look into it. I mean,
Lordship.
because one judgment has been passed by this court only in Guwahati, wherein it has been made clear that in 223, the complaint case is filed, the notices has to first go to the complainant.
Yes, written application has to be
Wait,
there.
complainant and witnesses have to be examined.
Yes,
And thereafter, a notice should go to the accused. And after hearing the accused, only the cognizance has to be taken.
yes. In this case,
This case hasn't been done.
no written complaint.
Hmm.
On that day itself, that cognizance was taken. That is why the petitioner is here.
Lordship, here, Lordship, only show cause notice has been issued, Lordship. That's
Chokos-
why the Lordship is not been
That is-
prosecuted, Lordship. That is, Lordship. And next date,
Then we'll have to see, issue a notice on this. I mean,
Yes,
we'll have to
Lordship.
examine this matter.
Yes,
yes, Lordship.
Okay, we'll come back.
Yes, Lordship.
obliged.
Item number 7.
Lordship, before going into the impugn order, Lordship, I may be allowed to state the background of the case. This, on behalf of this petitioner, the case was registered, and then she had given her statement on 161, 164, and thereafter the trial commenced. And on 26/8/2025, she was summoned. She was examined in her examination in chief. She deposed a statement which is a little contradictory as she stated in 164. That is why, considering that the perjury was initiated. Your Lordship may kindly have Annexure 678, page 78. This is the Annexure 6, page number 78. This is the recording of statement, examination in chief. May I read?
Yes.
Yes. I'm acquainted with so-and-so for long time. I forgot that
Annexure,
Annexure 6, page number 78.
page number
78.
78, yes.
This is the examination in chief of petitioner.
Hmm.
I'm acquainted with so-and-so. This is the accused person. For a long time, I forgot the date, but it was in the year 2022.
Pritam Pangia is who?
He's the accused person against whom this petitioner had lodged a FIR.
Hmm.
And the case is pending before the CJM.
CGM.
Yes, Pasigat. He asked me to come to Doimuk and manage a vehicle for me. The driver brought me to Silapata, where I met Sri so-and-so, the accused person, and his brother, namely so-and-so. Thereafter, I was taken to Likavali Tourist Lodge by so-and-so and his brother. After reaching Tourist Lodge, all of us had some wine. After some time, so-and-so went to another room as we booked 2 rooms, and so-and-so, this is accused person, and I were alone in the room. Meanwhile, I and so had some argument during which firing took place. Accused so is standing on the dock and he explained that his office name is so. I woke up Sri so and asked him to take me to hospital because I sustained bullet injury. Accordingly, he took me to Likavali Hospital where police also came there. In fact, medical staff informed the police I was referred to Dibrugarh. Next part. I called my sister, namely so from Likavali Hospital, and informed her that I sustained bullet injury. Thereafter, my sister informed the matter to my brother. He reported the matter to Naharlagan police. Subsequently, my family and Naharlagan police caught us at Assam, maybe before reaching Laluk. Thereafter, I was taken to TRIMS, where I got admitted. Firing was resorted twice. This is the relevant portion. My statement was recorded by CJ Madam, that is before the magistrate. As per the direction of the family member, I stated before the magistrate and police that the accused so shot me. But I'm not sure whether he shot or not because we were drunk. This is the statement. And considering this statement, this perjury, giving false evidence was initiated under section 229 BNS. And down below, it is the, I assume that this is the preliminary inquiry law. In the last paragraph, law said. In the FIR, the witness has alleged that accused so fired at her with his pistol, and she was shot on her right upper leg at Tourist Lodge, Likavali. Her statement was recorded under section 164 clause, subsection 5 of CRPC, during which she deposed on oath that accused so took out his gun and shot her twice on her right knee. But today she deposed before this court under oath that she had no knowledge who shot her, but she had implicated the accused person so on being instigated by her family member. Before recording the statement of the witness, this court alerted her that her statement is already recorded under section 164 CRPC, and she may be prosecuted for perjury if she is deviated from her statement recorded under section 164 CRPC. Upon perusal of the content of the FIR, the statement recorded under section 161 CRPC, the statement under section 164 CRPC, and the examination in chief, this court found that the witness has given false statement. Therefore, it is a fit case to take cognizance under section 229 BNS for committing offense of perjury. Therefore, the witness is directed to show cause as to why she shall not be prosecuted under section 229 BNS for giving false evidence in judicial proceeding. This is the recording. And thereafter, the impugn order was also passed. The next page, page number 81. It is same as the earlier.
So what is the procedure that should have been followed?
Procedure is firstly 215, section 215 of BNSS.
205.
215, 215. Merit. 215. Prosecution for contempt of lawful authority of public servant, for offense against public justice, and for offense relating to documents given in evidence. 1. No court shall take cognizance that the relevant portion would be from except on the complaint, that is except on the complaint, paragraph number 2.
Yes.
Except on the complaint in writing of the public servant concerned or some other public servant to whom he is administratively subordinate, or some other public servant who is authorized by the concerned public servant to do so. This clause B. Offense punishable under any of the following sections of 1, that is Bharatiya Nyaya Sanhita 2023, namely section 229 to 223, that it falls under this B clause 1.
Which we were? 229 to 233.
Yes, because this has taken cognizance against the petitioner under 229. Now, the other is not relevant. Now, this procedure, now 379 is the procedure. Section 379, again, 379. Earlier it was 340 CRPC. Section 379.
Yes.
Yes. Procedure in case mentioned in section 215. When upon an application made to it in this behalf or otherwise, any court is of opinion that it is expedient in the interest of justice that an inquiry should be made into an offense referred to in clause B, subsection 1 that we have of section 215 that we have gone just now, which appear to have been committed in or in relation to a proceeding in that court, or as the case may be, in respect of a document produced or given in evidence in a proceeding in that court, such court may, after preliminary inquiry, if any, as it thinks necessary, A, record a finding to that effect that has been done, make a complaint thereof in writing, send it to a magistrate of first class having jurisdiction. This is the procedure. After preliminary inquiry, then a complaint in writing, and then it has to be sent to the judicial magistrate first class. Since the purported offense has been committed before the CGM, he cannot act as a court because he is the complainant in this case. So it has to be referred to first. It has to be referred to the judicial magistrate first class.
Yes.
Lordship, as per this order, Lordship, it is intermediate order. It is not a final, Lordship. Or moreover, so Lordship, in this order, the last portion.
But what is intermediate in this? I mean,
Lordship,
there is a specific order of.
Yes, Lordship. Because Lordship, here, Lordship, that next date is also fixing, Lordship, on 2022, Lordship. Or Lordship, here, Lordship, the case is that, Lordship, here, Lordship, that only this last person, Lordship, may, Lordship, kindly, Lordship. Therefore, the witness is directed to show as to why he shall not be prosecuted under Section 229 BNS for giving false and judicial proceeding. Lordship, it appears that, Lordship, on the examination chief only, that court has got to know that her statement is perjury, Lordship. On that, after that, Lordship, this order has been passed, Lordship. It's not like this is he's been already taken cognizance. Cognizance has not been taken place yet, Lordship.
But it says like, therefore, it is a fit case to take cognizance.
Yes, fit case, Lordship, but it is
fit case to take cognizance under so and so. Therefore,
yes, Lordship.
Witness is directed to show cause as to why she shall not be prosecuted.
Yes, Lordship. So that means it's not been initiated yet, Lordship, because as to be initiated, Lordship, there's certain procedure to be followed, Lordship, that is 379, Lordship. So at this moment, we don't know whether
this is only the reason, maybe.
Yes, Lordship.
I mean, his reasoning, then he has asked to. So he is planning to do inquiry.
Yes, Lordship. This inquiry, Lordship, exactly, Lordship.
I believe that inquiry has already been done. That has been that was recorded in the examination in chief, Lord.
Where?
Page number 79.
Hmm.
This is, I have already read this.
Ah,
Page number 79. That last paragraph. This is the preliminary inquiry, Lordship.
Lordship, this is only recording of his reasons.
Lordship, reasons only, Lordship.
Recording of his reasons.
It's last, Lordship, in the next page, Lordship, 80, Lordship.
Because in the...
It is there, Lordship. Therefore, the witness directed show cause as to why she shall not be prosecuted, Lordship.
Lordship may have the page number 80. Kindly page.
Oh, 80?
Yes. Fifth line.
So this is his reasoning. I mean,
yes. Before recording the statement of the witness, this court allotted
where?
Fifth line.
Fifth line from top.
Yes.
Before recording the statement of witness,
this court
alerted her that her statement is ready. Yes, her statement was taken only. She
Her
may be
statement was-
prosecuted for perjury if she is deviated from her
Yes.
statement, and so and so. On perusal of the content of the so and so, examination, this court found that witness has given false statement.
Yes.
Yes.
That means the preliminary inquiry has been done. And thereafter the order has been passed, taking
No,
cognizance.
no preliminary inquiry.
No, no, Lordship.
Cognizance has been taken. So cause as to why she should not be prosecuted, that is the cognizance. Order is very clear, Lordship. It is a pit case to take cognizance under section 229 BNS for committing offense of perjury. Therefore, the witness is directed to show cause as to why she shall not be prosecuted under section 4 giving false evidence in judicial proceeding. Cognizance has been taken. That is why
So cause Lordship is there, Lordship. So cause that's why she shall not be Lordship.
but if it is a show cause notice, then it has to be clear it is for the preliminary inquiry or not. But it is not reflected about the preliminary inquiry.
Lordship, then Lordship, let me Lordship call for this record, Lordship, whether any proceeding has been initiated or not, Lordship, before passing any order on this, Lordship.
This is the last order, Lordship, and the case is fixed on 28th of next 22nd of next year, January 2026. And Lordship, mere inaccuracy in the statement, Lordship. Mere inaccuracy in the statement, Lordship, will not attract this case of perjury, Lordship. Because this petitioner has not completely retract her statement. Only there is slight contradictory statement has been given before the on oath. I mean, this chief.
See, first is record a finding to the effect. The finding he has given.
Yes.
Then make a complaint thereof in writing. Complaint to whom?
To as per this provision,
Complaint it should have been given by
this chief judicial magistrate.
Magistrate.
He will be acted as a complainant.
officer. He will have given a complaint to this person.
Yes. Judicial magistrate first class. Judicial magistrate first class. JMFC.
215 says, is a slip 215.
Yes,
So no court shall take cognizance
yes.
except on complaint in writing
Hmm.
of the public servant concerned.
Yes.
Who is the public servant here?
He, learned CJM will act as a public servant here.
He will be the complainant
Yes,
or of some other public servant to whom he is administratively subordinate,
yes. For some other public
or
servant.
some other public servant who is authorized by the concerned public servant so to do.
Yes,
So
That-
complain in writing of the public servant concerned. So initial statement was 164 statement was made before his judicial magistrate.
no, it was learned CJM Pasigat before the CJM Pasigat.
Before the CGM Pasigat.
Yes,
Then
before the same court.
huh?
Before the same court.
Before the same court.
Yes,
Then I mean, when the statement is made before the same court
that I have annexed at
of any offense punishable under any
section 229. That is the section 229. He invokes section 229. That is section 229 is the giving false evidence.
No,
Yes.
correct. Then that I understood.
Yes.
So he has taken cognizance already.
Yes.
See, the issue summons to PW is 2, 3, 4. So basically, he is going to decide the matter on perjury.
Yes.
Lordship, it is that so also, Lordship, he should have come before the court in the way of Lordship, revision, Lordship. Because revision is lying, Lordship, in such kind of order, Lordship. Because he challenges his order, Lordship, which is not a Lordship final order. This is intermediate order, Lordship. The revision is lies, Lordship.
The cognizance taken is an order.
Lordship, but here, Lordship, rightly pointed out, but Lordship, as per the Lordship, this last Lordship line as whether directed to so-called why she shall not be prosecuted. It's not like she is prosecuted, Lordship.
No, so prosecution, that is a perjury case. Cognizance
Yes,
has been
Lordship.
taken and asked for evidences.
Yes.
Why it should not be taken I mean, perjury case should not be. So already, as far as perjury, that has been that cognizance is taken. But whether perjury is committed or not, that will be examined after examination of the PWs.
Yes.
Lordship, that is told dear Lordship, because this procedure has not been followed, Lordship. It is dear Lordship. 379 should have been followed, Lordship, before taking that step, Lordship. But the Lordship, the thing is, Lordship, again, Lordship, it is this petition is maintainable or not, Lordship, because this comes under provision, Lordship.
This is a final order, Lordship. It can be.
The cognizance taken is an order. I mean, it's an order.
It can be interfered, Lordship, and the liberty is always there. Even if this impugn order is quashed, the liberty will be there for the learned Chief Judicial Magistrate to proceed in writing, making a complaint.
So next date is fixed on 21/2026.
Yes.
So nothing has happened in between.
No.
They do have no idea, Lordship,
No.
because
Because there is no
Other
date.
witnesses were.
No other date.
yes, Lordship. Otherwise, Lordship, they have specifically
So
some.
we issue notice and we'll issue notice and for time being we'll stay the proceeding.
Yes.
Then we'll consider it.
Yes.
Lordship, stay proceeding, then the proceeding will not start, Lordship. Otherwise, Lordship may, Lordship.
No. This
in respect
this
only
taking
to-
cognizance that cognizance has been taken without following the procedures. Then I mean it's a wrongly taken cognizance that has to be stayed.
Then Lordship, then perjury is there, Lordship. Then Lordship has direct to follow the procedural law, Lordship. It may be revert back, Lordship. It can be also be done, Lordship, otherwise. Otherwise, they have direct to Lordship, before the Lordship going on the
It
Lordship.
can be remanded.
Yes, Lordship.
This may be quasi lordship. Then liberty is always there. If it is remanded back and
No,
directed, then
I mean,
it will be adverse order.
If the entire Lordship,
petitioner.
this order will come, then this next date, Lordship, this already here, Lordship.
Lordship may issue notice and then this in respect of only against the perjury, this may be state lordship, not the
No, not other things. Other
No,
things, so definitely
yes.
not.
not
Yes,
the
sir.
main.
Only against only that I mean the cognizance taken order.
Yes.
That's what, nothing else. Then it has to be, I mean, little bit examine little bit details. I mean,
Yes,
the
Lordship.
provisions hasn't properly followed. The prima facie, it looks like it hasn't been followed because it doesn't show from the order.
Lordship. But
From the-
perjury is
from
there,
the-
Lordship, but the thing is that have not followed the procedural, Lordship.
Correct.
Yes,
So
Lordship.
procedural lapses, I mean, obviously, I
Yes,
mean,
Lordship.
right, heard Mr.
B. Padum.
B. Padu, the learned counsel appearing for the petitioner. Also heard Mr. L. Hage, the learned APP for the state. This is an application filed. This is the instant petition is filed under section 528 of BNSS 2023 for quashing and setting aside of the order dated 26/8/2025 passed by the Chief Judicial Magistrate Pasighat East Siang District, Arunachal Pradesh in connection with LKB-PS case number 30/2022 under section 326/354 capital D/506 para Roman 2 capital stroke 201 para Roman 3 IPC read with section 30 of Arms Act full stop. Arms Act, whereby the learned CJM Pasighat had taken cognizance of perjury under section 229 of BNS 2023 against the petitioner. Full stop. It is the case of next para. It is the case of the petitioner that an FIR was lodged on 10/12/2022 by the petitioner against one Sri Pitam Pangia, alleging that Sri Pitam Pangia called her to Likavali on 9/12/2022 at about 2 p.m. and at about 2 p.m. full stop. It was alleged that on reaching Likavali about 4:30 p.m. after spending some hours at a tourist lodge in Likavali, at about 21 hours, Sri Pitam Pangia started molesting the petitioner forcefully, and on refusal, the aforesaid Pitam Pangia fired at her from his licensed pistol on the right upper leg of the petitioner. The petitioner, thereafter informed her brother regarding the incident and about the incident, and accordingly, the brother of the petitioner informed the Naharlagun police station, and the petitioner was taken for medical treatment thereafter. Next paragraph. On receipt of the FIR, the police registered the LKBPS case number 30/2022 under the aforementioned sections. Next paragraph. During the investigation, the statement of the petitioner was recorded under 161 CRPC, and her statement and her deposition under section 160 CRPC was recorded on 4/1/2023. On completion of the investigation, charge sheet was filed on 20/1/2023 against the aforesaid Pitam Pangia and two others under section 307/365/354 capital A /506/205/34 IPC read with section 27 of Arms Act, full stop. Next paragraph. The cognizance in the matter was taken by the Chief Judicial Magistrate. Chief Judicial Magistrate where? Chief Judicial Magistrate Pasighat.
Pasighat East.
Pasighat, East Siang District.
Yes.
East Siang Districts. And since section 307 IPC and section 27 Arms Act was invoked in the charge sheet against the accused Pitam Pangia, the matter was committed to the district and session judge Pasighat on 27/5/2024. However, now the date is don't write the data. It was transferred to the district and session judge. Then you write on 27/5/2024, the district and session judge Pasighat dropped section 307 IPC, and since the punishment for section 27 of Arms Act is only up to 7 years, the district and session judge transferred the case back to the learned CGM, Pasighat. We'll stop. Thereafter, the learned CGM Pasighat had passed an order dated 7/10/2025. Yes, 7/10/2024. This is a charge framing order or what?
Yes, this is the charge framing order.
Had passed an order dated Iman and so, wherein section 27 of Arms Act was altered to section 30 of Arms Act, and thereby framed charges against the accused, against the aforesaid accused Sri Pitam Pangia under section 326/354D/506 para Roman 2/201 para Roman 3 IPC read with section 30 of Arms Act. Full stop. Thereafter, the case was fixed for examination of prosecution witness number 1, that is the petitioner. And on 26/8/2025, the petitioner appeared before the CGM Pasighat and deposed her statement in a statement in examination in chief. When she deposed her statement, when she deposed her examination in chief, she mentioned that as per the direction of the family member, she stated before the magistrate and police that accused Pritam Pangia sought her, but she was not sure whether he shot or not because they were drunk at that point of time. On such deposition, the learned CGM took cognizance of the offense of perjury under section 229 BNS against the petitioner because petitioner, due to the fact that she had where is that once
What's the
in 164 statement?
161st?
So perjury is taken because of 164 statement only.
Yes.
So where is that?
Annexure to page 18.
Page
18. 1
18.
Mm. 18161 lordship.
Type copy would be 21A type copy. 21A.
Due to the fact that under on her statement on her deposition under section 164 CRPC, she had stated that
Relevant portion would be 21 page 21B paragraph 3.
3.
Yes.
She stated, she deposed so and so stated that while she was standing near him, the accused, the aforesaid accused, namely Pritam Pangia, took out his gun and shot at her twice on her right knee. Full stop. Accordingly, the learned CJM, Pasighat Pasighar, uh, on 26 August 2025, while recording her deposition, while recording the petitioner's deposition, came to a finding while his note dated the same as by the dated same and the same, the relevant part of which is extracted herein below. So just put dot quotation dot करिए. Upon perusal of the content of the FIR, comma, the statement recorded under section 161 CRPC, comma, the statement under section 164 CRPC, and the examination in chief, this court found that the witness has given false statement. Full stop. Therefore, it is a fit case to take cognizance under section 229 BNS for committing offense of perjury. Full stop. Therefore, the witness is directed to show cause as to why she shall not be prosecuted under section 229 BNS for giving false evidence in judicial proceedings. Full stop. Next para. In view of the aforesaid finding, in an order of the same date, that is 26/8/2025, the learned Chief Judicial Magistrate took cognizance took cognizance of the matter under section 229 BNS for committing offense of perjury. And accordingly, full stop करके then and A capital, and accordingly the petitioner was directed to show cause as to why she shall not be prosecuted under section 229 BNS for giving false evidence in judicial proceedings. The learned CJM further issued summons to PW numbers 2, 3, and 4 and fixed 22/1/2026 for examination of the aforesaid PWs. Full stop. Mr. So-and-so, the learned counsel appearing for the petitioner submits that in the instant case, the cognizance has been taken by the learned CJM without following the due procedure as laid down in the CRP, in the BNSs. He submits that while before taking cognizance, which were the sections
250.
he has taken cognizance the 229, na?
229, yes, IPC or BNS.
Under 229, Lordship. For giving false evidence, Lordship.
One second.
Mm. 229.
Then which are the sections you have mentioning?
215,
215 and
379.
yes.
That is BNSS, Lordship.
BNSS.
Correct. Then he submits that while taking cognizance under section, you have written that, no? Cognizance under section 229 of BNS, the learned Chief Judicial Magistrate learned Chief Judicial Magistrate learned Judicial Magistrate has not followed the provision laid down in section 215, which mandates that no court shall take cognizance of any offense punishable under section 206 to 223. No, you write under section 229, right? Any offense punishable under section 229 229. See, I mean, no court shall take cognizance of any offense under so and so, except on writing a complaint, right?
Yes.
Except on the complaint in writing of that court or by such officer of the court as the court may authorize in writing in that behalf, comma, or some other court to which the court is subordinate. He submits that no such complaint.
Yes.
No such written complaint was no such written complaint was made in the instant case. He further submits that 279, no?
379.
Sorry, 379. He further submits that the learned citizen has not complied with the procedure which has been laid down under 379 of CRPC as of BNSS while taking cognizance of the matter under section taking cognizance of the matter in the instant case under section 229 of BNS. He submits that he submits that as per section 379, a preliminary inquiry needs to be done before taking cognizance of a matter. Before taking cognizance of an offense under section 229 of BNS. These are all your submissions, nothing else?
Yes. Only on procedure.
Hmm?
Only on procedure.
I mean, only this two, I mean, violation of two sections, to these
Yes.
procedural sections.
Yes.
In view of the aforesaid, the learned counsel appearing for the petitioner submits that since there are mandatory procedural lapses occurred while taking cognizance in the instant case, the impugn order of taking cognizance dated
26/8.
26/8/2024
25.
25 is liable to be set aside and quashed. Full stop. Next, on the other hand, the learned MSL Hage, the learned APP submits that there is no procedural lapse as such in the instant case while taking cognizance of the matter as the matter is as the CGM as the learned CGM is yet to take cognizance of the matter, and only a show cause notice has been issued in the instant case for showing show cause notice has been issued in the instant case to the petitioner to show cause as to why the cognizance of offense of perjury should not be taken against her. Is it your submission?
Yes, Lordship. As per this order, Lordship, it appears.
No, this is your submission,
Yes,
right?
Lordship.
That's what you're saying, no?
Yes,
That
Lordship.
this is a premature matter.
Yes,
I mean,
Lordship.
cognizance hasn't been taken
Yes,
as yet. That's
Lordship.
what you have said.
Yes, Lordship.
Matter. So therefore, this application has been filed prematurely, and therefore is liable to be set aside, liable to be dismissed. Full stop. This court has gone through the materials brought before this court and also heard the submissions made by the respective counsel appearing for the parties. It is seen, it is prima facie seen that it is prima facie seen from the order dated 26/8/2025 that cognizance has been taken by the learned CGM under section 229 BNS void his order dated 26/8/2025 full stop. However, a plain reading of the order dated 26/8/2025 does not reveal whether the procedure laid down under section 379 of BNSS has been followed or not. Full stop. Therefore, this court finding prima facie therefore this court finding prima facie material for consideration don't write like that. Therefore, this court is of the considered opinion. Don't write prima facie, considered opinion that the instant case shall require detailed consideration. Therefore, let notice be issued in the instant case, returnable within 4 weeks, returnable in 4 weeks. Since the learned APP has put appearance on behalf of the sole respondent, formal notice on respondent number. Formal notice on respondent number is dispensed with. Full stop. In the interim, the proceeding in respect of
Only perjury, Lordship.
yes, proceeding in respect of cognizance taken under section 229 BNS for perjury for offenses of perjury against the petitioner is kept in abeyance.
Lordship.
Is kept in abeyance till further order of this court.
Lordship.
Till further of the order of this court. List the matter in
After court vacation, Lordship.
list the matter on 11th of February.
Lordship.
11th of February.
Then, Lordship, in the meantime, Lordship, this record may be called for, Lordship.
This
Scan copy of the teacher.
scan copies of scan registry to call for the TCR. Registry to call for the scan copies of the TCR in connection with LKBPS case only. It is registered at that only what?
Yes, Likavali PS.
Likavali, and GR number is already.
GR number is there.
LKBPS case number.
GR number
30/2022 in bracket GR number 21322 from the court from the court of learned CJM Pasighat.
Yes.
Hmm?
Yes.
Pasighat
East Siang district.
East Siang district. That's all. That will do.
Lordship.
Right.
My lord, this is very limited issue. Here, challenging the order of alteration order passed by the learned JMFC Ethiopia.
What?
Earlier, the maintenance order was passed by the learned JMFC Ethiopia. The maintenance case was filed by the petitioner wife against the respondent husband, wherein the learned JMFC Ethiopia passed a maintenance order of rupees 30,000 for two minor children. And that under the DB Act.
Now it has been decreased.
Yes. The reduced
So
from,
notice on this, nothing else.
yes, in violation of.
We will not
yes.
pass any interim order in this.
My lord, my humble prayer, this is a matter of maintenance regarding the minor child. So operation of impugn order may be suspended till.
No, you are, how much you are getting now?
10,000.
10,000 is fine.
This is minor, two minor, the necessity.
But I have gone through this. 30,000 was exorbitant, which was given to you.
So far, even then, my lord, in violation of provision, section 25 clause to clearly stated provision there.
What is the provision?
The interim order or the maintenance order can be modified or altered only after filing appropriate application, and at that application must have substantiated the change of circumstances. Change of circumstances.
Earlier order was passed.
Yes.
On the basis of some affidavit.
Yes. That is completely violation of the stated provision, section 25 clause 2.
That's fine. We'll issue notice on this. We'll give a short date, but no stay in this one.
All right.
Heard Mr.
And moreover, this my
the learned counsel appearing for the petitioner. Also heard Mr. El Hage, the learned APP for the state. This is an application under section 528 of BNSS 2023 for quashing and setting aside of the impugn order dated 13/10/2025, passed by the learned Judicial Magistrate First Class EPA in domestic violence case number 40/2024. 40/2024. Registry to call for the TCR. Registry to call for the TCR.
Scan copy of the TCR also. Scan copy of the TCR.
Scan copy of the TCR in connection with DV case number 40/2024 pending before
JMFC Ethiopia.
JMFC UPA, full stop. Let notice be issued on respondent number 1 by speed post with raised registered speed post, steps for service of notice on respondent shall be taken within. It will be holidays now.
Yes,
We'll just put it like that with, within 3 days. If you can take it today, if possible.
yes, moreover, I may allow to personal service also.
No,
for
that's not required now. You take first speed post, then we'll see.
Sure.
Notice on respondent number 2 is dispensed with as the learned APP puts in her appearance in the matter. Let the matter be listed after 4 weeks. After 4 weeks. On a date to be fixed by the registry.
All right.
I'll advise.
Item number 11, it's an unlisted matter.
May I please, my lord? This is prayers bail application, my lord. My lord will find the FIR at phase 14, my lord. 1-4, my lord. And type copy is at 1-5, my lord. May I read, my lord, type copy?
Yes, yeah, Mr. Ate.
Yes, my lord. This is a election issue, my lord, and perhaps, my lord, the counting, everything has been done. The result has already been declared, my lord, so far as the Panchayat election is
No,
concerned.
correct. I mean, the allegation is only the pouring some.
Yes.
This thing.
Yes, my lord.
So what is
Only the PDPP is there, my lord. Other PDPP section is there. Other sections are available. Lord.
Otherwise, also, I mean, what is?
Yes.
What will you do keeping him inside the jail or whatever?
Yes.
Arresting him.
Yes, ma'am.
Heard Mr. Learned Counsel appearing for the accused applicant. Also heard Mr. T. Ate, the learned APP for the state. This is an application under section 482 of BNSS 2023 for granting PRS bail to the accused applicant in connection with Raga Police Station case number 33/225 under section 324 in bracket 2 stroke in bracket 2 BNS read with section 136 in bracket 2 in bracket capital B read with section 3 of Prevention of Damage to Public Property Act 1984. An FIR, the FIR dated 17/12/20 was filed before the Raga Police Station, alleging that filed by Sri Goi Noidu, the presiding officer of 54 Chikom 6 Roman 6 police station, alleging that the accused applicant, who was the BJP polling agent, had deliberately poured cold drink into the ballot box kept outside the polling booth. Full stop. On receipt of the FIR, the Raga PS case number, Raga Police Station case number 33/2025 was registered under the aforementioned sections. Full stop. The learned counsel appearing for the accused applicant submits that the election is already over. Results are declared.
Yes, madam.
Results are also declared. He further declared, full stop. He further submits that there was no damage to the public property as alleged in the FIR. However, he is apprehending arrest as the police has visited his residence, inquiring about him. Full stop. Full stop. In view of the aforesaid, he submits that in view of the aforesaid, he submits that the accused applicant should be allowed to go on pre-arrest bail at this stage. As this stage, the learned Mr. T. Ate, learned APP, appearing on behalf of the state, has submitted that election is already over, and results are declared. Therefore, what?
Custodial interrogation is not at all required, madam.
Therefore, custodial detention of the accused applicant may not be required in the instant case, full stop. Taking into account the submissions made by the learned counsel appearing for the respective parties, as well as going through the materials brought before this court is of the considered opinion that the accused applicant should be given the privilege of going under pre-arrest bail at this stage, full stop. Therefore, it is directed that in the event of arrest of the accused applicant by the investigating authority in connection with Raga PS case number 33/2025, the accused applicant shall be released on furnishing of a bail bond of rupees 20,000 with a security of like nature to the satisfaction of the arresting authority, subject to the following conditions. Number one, that the accused applicant shall appear before the investigating officer within a period of 10 days of passing of this order. Number two, the accused applicant shall cooperate with the investigation and make himself available as it when called for by the IO. Next, number three, the accused applicant shall not tamper or hamper with the investigation in the instant case in whatsoever manner. Full stop. Accordingly, the instant anticipatory bail application is disposed of as allowed.
Matter number 9.
May I, Lordship? Lordship, on 22nd part hearing was done, and after that I would like to realize some order being passed by this.
See, I mean, today it will be difficult, I think.
Lordship, based on this order and judgment ruling, it will be very crystal clear for Lordship to pass order. Since there are 2-3 immense judgment.
I mean, it has to be examined. I mean, today I don't know that. Maybe what is the?
Yes.
What is the case law that that you have got?
Okay, it's reported in GLT 2025. This is one, and one is by Lordship only. It's
No, that's in a point wherein it was.
yes, in this the relevant para that's in paragraph number 15 to 35, all are relevant because after considering the section 21 clause 2 also, and main part is there in section para 32, 33.
Which one you are referring to?
This Retaha. CRP 25 of 2024.
Yes. Give me the paragraphs.
Paragraph number from 15 onwards.
No, onwards or paragraph. Tell me paragraph 15 to
paragraph 36.
All paragraphs.
Yes,
all
Lordship, because
paragraphs
where means they had considered all the facts and circumstances.
Give me facts. What was the specific question asked to you? When it was sent back?
Yes.
It was sent back, whether it will be heard de novo or it will be heard on the basis of the appeal on the materials available for the court. That was the question, right?
Yes.
Now, what is the finding here?
Here in this case, it was also filed before the civil judge senior division.
Correct.
Then subsequently, the civil judge senior division has tried the case, and later on, it has come before this honorable court as form of civil revision petition.
Now, tried the case.
No, just challenging the impugn.
Now, you tell me the facts very briefly. I mean, see, one order was passed by the Kebang.
In my case.
This case.
This case here means actually it's a student election related. Here means pecuniary jurisdiction was there was a pecuniary jurisdiction issue. Where means
our specific question was, see, there was an order filed. Okay, there was an order.
Yes.
Whatever way, I mean, whether you were there, not there. I mean, you were present, but you were saying that you were not aware. Correct. The order was passed by the village Keba. then Village Keba, isn't it? That
No,
was the
no,
case.
Lordship, in Village Keba, we were present
Huh.
and Village Keba has passed the judgment.
That's correct. That's
Yes.
what I'm saying. I mean, the land is yours, right?
Yes,
You have
yes,
been
Lord.
cultivating the land. That is
Yes.
your thing.
Yes.
And the land, your land was given by somebody, one person to another person.
Yes, Lordship.
I mean, and you were not aware of this.
Yes.
Now these two person have come.
Yes.
That yes, but then the village keba happened.
Yes.
And in the village keba, it was I mean, there's a direction that you should pay 50,000 rupees.
Yes.
Correct? 50,000 rupees to the I mean, the person who has, I mean, given it wrongfully.
Yes. Not to me. I am not supposed to pay that 50,000.
50,000 will be
Is to-
the other person. Sorry.
Yes. Yes.
The land will be with you only.
Yes.
But 50,000 rupees has to be paid by the grandfather. Who is that petitioner?
That person
Hmm.
whose father has sold to that father.
So 200 rupees was
Yes.
taken.
Yes.
He has said, "Okay, this is my land, you take it."
Yes.
So allegedly sold it.
Yes.
Now the Keba has come to a decision that it was wrongfully given. So 50,000 rupees should be paid by the grandson
Yes.
to the person from whom he has borrowed 200 rupees.
Yes, Lordship.
Correct. And now the thing is that like the Keba decision has been delivered. Now you have gone directly to the civil court.
Yes.
Gone to the civil court. And in the civil court, I mean, without, now the question is before the civil court is whether it will be taken as an appeal or it will be taken as a de novo trial.
Yes, Lord.
Correct? That is the thing.
Yes.
And like this civil court has gone ahead with the civil, it was filed as an appeal only.
Yes, Lord.
But on the appeal was converted to a trial.
Yes.
Correct? And witnesses have been taken, all trial happened, and order was passed. And you are challenging the order now, saying that it could not have been done that way.
Yes.
Correct. That
Yes,
is,
Lord.
and so you need to show me show this court that while this appeal, when an appeal is being filed, then that cannot be treated as a plaint, and a trial cannot go ahead with like that. Is it the thing?
Lordship.
That was the query.
That was the query I've raised.
Yes.
Yes.
And now whether the query can be answered by this, you say yes or no? No.
Yes, yes, Lordship. It's specifically by paragraph 35 of this.
35.
Yes.
Hmm.
May I read, Lordship?
Yes.
In view of what has been discussed here and above, and in the light of the law settled by the Honorable Supreme Court, coupled with the relevant provision of law as considered here and above, I'm of the considered view that it would only be appropriate for the suit to be presented before the Court of Learned Civil Judge Junior Division concerned.
Hmm.
The Learned Civil Judge Senior Division ought to have returned the plan to the plaintiffs,
Hmm.
public respondent number 1 to 4, for approaching the Court of Civil Judge Junior Division.
Hmm.
As the Arunachal Pradesh Civil Courts Act 2021 has laid down the pecuniary jurisdiction of a Court of Civil Judge Junior Division
Hmm.
to a subject matter whose value is not exceeding rupees 10 lakhs. Although the Court of Civil Judge Senior Division would not be quorum non-judice, thus I'm of the view that since the Civil Courts Act has laid down the pecuniary jurisdiction of a court of learned.
But that doesn't answer the question that has been raised by the court. I mean, that's fine. That is one of your ground that it should not have been taken up by the senior division.
Yes,
Correct?
Lordship.
That was one thing that is there. But what about the query raised by
Yes.
the court?
Now, my point is that if this type of de novo being tried by the Civil Judge Senior Division biasly, then it will be continued. Therefore, in this regard, in paragraph 32, Lordship, this type of practice need to be stopped. So paragraph 32, this Lordship may turn this page 19, means clause 7.
Mhm.
Yes, 7.
The power of issue of writ certiorari, what is that?
This is regarding read. After after that, let me complete this para, Lordship. Then there is one last para. The High Court may feel inclined to intervene where the error is such as, if not corrected at that very moment, may become incapable of correction at a later stage, and refusal to intervene would result in travesty of justice. Lordship, if this same is not reversed, then
I mean, this matter will take some time. I mean, we'll not be able to finish it. I will not be able to write the order also. Whether it's possible today, it will not be. He says.
I will not. As for me, subject to your lordship convenience, of course, I will not take
I'll
my
release
time.
it. I mean, let it be. If I come, then I'll hear it after the opening. Today it won't be possible. I mean, there is no hurry in this matter. Is there any hurry?
Hurry, my lord, as in that there's a stay operating. Now the decree is in my favor. But because of that stay.
Stay is there, na?
Stay
yes,
is
Lordship,
there.
stay.
I mean, we'll hear it up in the opening. I'll release it from the stay part hard, huh? I'll release it from the part hard. The problem is that, I mean, there are certain orders has to be passed in the chamber. Bill, matters and all these things. Then today is the last date. Then if I do not upload this, then it will be vacation, the problem.
Yeah, that I understand, Lordship.
That's why it's late. In fact, on Monday,
Because
it said on the last day, it's not.
Actually, it was, I mean, in the division bench, it took some time.
Well,
That's why, I mean, this bench could not take it up.
otherwise, on my part, I could have just submitted the.
So let us
judgment
hear it in the hearing, but because I'm not sure about the roster. Otherwise, I would have kept it, this thing only. But roster, I'm not sure because I think I should not keep it part hard.
No.
So let me be coming in the, I mean, it will take some time, I know. It is not a simple issue as you're portraying.
That I understand, Lordship.
My issue is regarding the maintainability, my lord.
Now, your issue is there about the maintainability, but maintainability issues are the most complicated issues.
But regarding maintainability, I have, I'm like.
But don't give me now. I think
Because if there is maintenance.
if I come on the reopening, then definitely I'll hear it this side. Otherwise, I mean, it will take some time. I mean, that I have some orders to be passed. Please, excuse me. From tomorrow it's holiday. So bail orders has to be passed. Some criminal petition also are there. Heard Mr. K. Tania, the learned counsel appearing for the petitioner. Also, Mr. D. Suki, the learned counsel appearing for the sole respondent. The matter is released from part hard. Let the matter be listed. When do you want it? Tell me. When do you want it?
Lordship, because it has been part heard before that bench also. So.
No, I mean, I'm releasing it because I'm not sure about, I mean, that otherwise I would have taken it up, but I'm not sitting here regularly.
January 20.
No, 20, I have fixed.
Well, let it be
weeks.
after 3 weeks or 4
3
weeks,
weeks.
my lord, without any fixed date, my lord.
Without any fixed date?
No.
Let it be listed in the third week of January?
Last week of January will be.
Last week of January. Okay, last week of January.
20, 29, why not? 24 January, 23rd or 22nd. 23rd or 22nd January.
Then we'll put it on 23rd of January.
Okay.
Let the matter be fixed on 23rd of January. If I'm here, I'll hear it out. Otherwise, some of the banks will hear it. Because
For
I didn't
admission,
keep it pending.
for admission hearing.
For admission hearing. For admission hearing.
Oh, bless my lord. On the last working day, generally the court doesn't sit for so long. my lord.
I mean, that's what I mean. Now I have to pass some orders. So that is the thing.
We wish a Merry
Because
Christmas
otherwise,
and a very Happy New Year, my lord.
Yes. Of course, Happy New Year to all of you.
Same
And,
to you.
and have a Merry Christmas to you all.
Same to you, Lordship.